Good morning. My name is Gerald Parker. I'm an attorney and founding partner of Parker Waichman. We are a national personal injury mass tort law firm with our headquarters in New York. So we're here today to talk about Elmiron, and the formal chemical generic name that it's known as is Petosan Polysulfate Sodium, also oftentimes referred to as PPS for short. And it's an oral drug that was approved by the FDA for people who suffer from interstitial cystitis, more frequently known as bladder pain or bladder pain syndrome. However, Elmiron is not the only treatment for interstitial cystitis that's available to physicians and also to patients. It is not the first-line treatment for interstitial cystitis. Well, Elmiron is actually manufactured by a company in Germany known as Benny Farmer Kemp and Company. They actually do the manufacturing of the pill. But I think what will be more familiar to people actually worldwide, but especially here in the United States, is who actually brought it to market, who got it approved, who marketed it, and who sold it. And unlike other drugs, which really have very limited number of entities involved in that process, for some reason, Elmiron has a lot of entities involved. The owners of the license at whatever point in time kept on moving the license around to different corporate entities, selling it, trading it, whatever. So it started off with a couple of companies that have the first name of Baker. Well, we're going to talk about one of them because that one took over from the other one, so we'll start off with Baker Norton. At that point in time, all the way at the beginning, before it was even a drug approved by the FDA, Baker Norton was owned by another company called IVAX. Now both Baker Norton and IVAX are now essentially owned by Teva. Baker Norton held the NDA. That's the new drug application. That's the application that a drug company has to file with the FDA to get approval to market their drug. And they held the NDA until 1997. In 1997, a California company called Alza, ALZA Corporation, which now is owned by Johnson & Johnson, they held the NDA from 98 to 2002. Like I said, Alza got acquired by Johnson & Johnson and one of their subsidiaries. And there's a whole bunch of Johnson & Johnson entities involved with Elmiron over the years. Janssen Research and Development held the NDA from 2002 to 2004. Janssen Pharmaceuticals held it from 2008 to the present. Janssen Ortho was involved. Ortho McNeil Pharmaceutical held the NDA from 2004 to present. All of those are Johnson & Johnson related entities. And then at some point in time, approximately 2005, Johnson & Johnson and their related entities made an arrangement with Bayer to co-promote Elmiron and to sell it, giving Bayer all the proceeds of the sales to the urologists in the United States. So we have a bunch of Bayer entities involved in this as well. Elmiron is used to treat interstitial cystitis, also known as bladder pain syndrome or bladder pain. there are a number of common symptoms to PPS-associated maculopathy. A patient taking the Elmiron could have blurred vision. They could have difficulty reading, difficulty adjusting to dim lighting, coming out of a bright room, going into a dark room, coming out of a house, going into the street at night. Problems with dark adaptation. They could also be suffering from problems with glare or blind spots. All of a sudden, maybe the colors are not as vivid as they used to be. Some people report night blindness. Some people report something called metamorphosia. It's the type of distorted vision which presents itself in your eyes as a grid of straight lines that sometimes appear wavy, and parts of the grid might actually be blank. People might first notice that they suffer from this condition when they're looking at mini blinds in their home. And then blindness. The underlying injury that is caused to the eye by Elmiron is an injury to the retina. A lot of our clients are misdiagnosed with various diagnoses, such as age-related macular degeneration, or AMD, for short. While both forms of macular degeneration, wet and dry, involve damages to the retina and causes loss in the center field of vision, the injury is much different than AMD. The area of the retina that is damaged from Elmiron is different. And I would say that the injury caused by Elmiron can be described as a quote-unquote fingerprint type injury that has a very unique presentation when retinal specialists perform retinal imaging of the retina. It just stands out because they had never seen this injury before the discovery of Elmiron. Some other misdiagnoses are macular dystrophy, pattern dystrophy, maculopathy, general, which is just a general damage to the retina, macular disease, retinopathy, Stargardt's disease, severe loss of retinal pigment epithelium with photoreceptor loss, sometimes referred to as RPE. The diagnosis that we are looking for in our clients after they get the retinal imaging that is required is pigmentary maculopathy, or changes to the pigmentary layer of the retina, or Petosan Elmiron toxicity. Another one would be Petosan Polysulfate Sodium Elmiron toxicity, or just drug toxicity. It is most often diagnosed using 3 different retinal imaging techniques. The first one is the fundus autofluorescent imaging, or FAF. Now, I'll describe that as more like actually a picture. It is like a photograph of your retina. And when you're looking at this photograph, if someone has Elmiron-related toxicity of their retina, it's pretty obvious in an FAF imaging. The other imaging that retinal specialists use is the optical coherence tomography, also known as OCT. And it's a different technology that shows a different presentation and shows some unique findings only related to Elmiron toxicity. Infrared fundus reflectance, also known as an NIR. And it's also another kind of imaging tool that has very unique findings when you're dealing with Elmiron toxicity. All three of these imaging tools are painless. They're relatively quick. Retinal specialists generally will have them in their office. And what we're finding is sometimes when one of them is positive, they end up doing all three. Each one gives you a little bit different look or perspective on the damage caused by Elmiron. Yes, Elmiron can cause serious and permanent damage to the retina, which can also cause a loss of vision. Now, I think as we discussed earlier, macular degeneration is a common misdiagnosis for the damage to the retina caused by Elmiron. While macular degeneration is damage to the retina, and it does cause center field of vision damage, it involves different method of action of damage. It involves leaky blood vessels that grow under the retina, or retina detachment, where it deteriorates. The injury caused by Elmiron is completely different. Absolutely not. But that may be indicative of damage to your retina caused by Elmiron. The real question is, at our office, in order to sue, in order for us to bring a lawsuit on your behalf, we have to have the imaging studies that show that you have damage to your retina caused by Elmiron. So if you have any of the symptoms of Elmiron-related damage, I would go to a retinal specialist, give them the history of your taking Elmiron, give them the history of your problems with your eyes, and let the retinal specialist and you decide whether you should undergo those imaging studies that I outlined earlier. One thing that's extremely important that has been brought out by a recent study, as well as noted in the new labeling that has been published by the defendants who are selling Elmiron, is that the damage to your retina can occur long after you stop taking the drug. That's correct. You could stop taking the drug 10 years ago, and the damage to your retina could be happening today. I think there's one study that actually noted that a person in the study was still having damage to their retina 10 years later. Without getting into attorney confidential information, based upon the information that's been published in the peer-reviewed literature, retinal magazines, ophthalmology magazines, without getting into any confidential information, based upon the published literature, including the literature published in ophthalmology magazines, retina magazines, and even the updated package insert that was recently released in June 2020. Many people who have reported Elmiron-related damage to their retina have taken Elmiron for about 3 years or longer. However, we don't have enough information to say that 3 years is the minimum, because there's been some people that have documented Elmiron-related retinal damage that have taken it for less. It appears that the cumulative dose over the years, when you add up all of the Elmiron that you've taken, people who have taken more Elmiron than others seem to be at greater risk. So there are people that have taken relatively little Elmiron also have reported having Elmiron-related retinal damage. And what's really important is you need to have follow-up retinal examinations after you stop taking the drug. Because, as I said earlier, it's been reported not only in ophthalmology magazines, but in the labeling that just came out in June 2020 that damages to the retina can occur after you stop taking the drug. Well, I'm a lawyer, not a doctor. But if I was taking Elmiron, and if I had any of those symptoms that I outlined earlier, then I would go to my ophthalmologist and have a discussion. And part of the discussion would be, should I see a retina specialist? And should I get the fundus autofluorescence imaging, or the optical coherence tomography, or the near-infrared fundus reflectance, or all three, to make a determination of whether the injuries that I have were caused by Elmiron. Parker Waichman has filed lawsuits both in federal and state courts, claiming serious and permanent physical damage to the retinas of its clients. Parker Waichman has retained some of the world's leading retinal specialists and others with extensive knowledge of Elmiron and its toxic effects on the retina. Anyone who's ever taken Elmiron and is suffering from one or more of the following: blurred vision, and I think we went over these earlier, blurred vision, difficulty reading, difficulty adjusting to dim lighting, problems with dark adaptation, glare, metamorphosia, blind spots, blindness, in my opinion, should see a retinal specialist who has the radiological tools, the imaging tools to confirm whether there is damage to the retina and if it was caused by Elmiron. Like I said earlier, the damage to the retina caused by Elmiron is what I would refer to as a fingerprint injury. That is, the damage to the retina that's caused by Elmiron had never been seen before Elmiron was available for sale. Parker Waichman represents clients in pharmaceutical and medical device cases in all 50 states. We're a national firm. We're a litigation firm. We don't collect cases and let other law firms do the work. We don't get cases and then refer them out. We litigate our cases. We don't sit around and hope the defendants will try to settle and then try to get in on a settlement. From our almost 4 decades of pharmaceutical and medical device litigation experience, we have found, without question, that the clients of the law firms that actually litigate their cases are more appropriately compensated than clients of law firms that sit and hope to piggyback on a settlement arrived at by others who actually did litigate the cases. In order to litigate the cases against giant corporations like we have here, I know that you can imagine, how do you do such a thing? How do you take on some of the largest corporations in the world? It must be very expensive. It is. It costs millions, tens of millions of dollars that we advance to the litigation. It takes an army of lawyers and paralegals. We have the army. Parker Waichman is well financed and has almost 4 decades of taking on the pharmaceutical and medical device manufacturers. And we know from firsthand experience that when you actually do the work, when you take the depositions, when you do the discovery, when it comes time for case resolution, our clients are going to benefit from that work. The attorneys at Parker Waichman have been involved in dozens of pharmaceutical and medical device litigations over the last 4 decades, starting with diacylstilbestrol, breast implants, Prozac suicidality cases, Fen-Phen, Zyprexa, Bauschalom, Renewit Moisture Lock, contact lens solution, which involved damage to the cornea, not the retina, Zyprexa, Ortho-Evra birth control patch, Yaz birth control, Medtronic infused spinal device litigation, TDF drugs, and so many others. In the Renew case, a lot of our clients had their cornea replaced, but unfortunately, you can't get your retina replaced. So well, that speaks to the damages. See, this is a real misunderstanding about the law in the United States. When you're claiming personal injury as a result of a product or someone's negligence, almost without exception in the United States, it is not a class action. There's only one minor exception, which we don't need to discuss, and except for that one minor exception, which deals with one unique state law regarding a particular type of litigation that causes injury, all cases in the United States claiming injury as a result of a product or negligence are individually filed. They're not class actions. And the simple answer for that is, in class actions in the United States, the damage has to be similar to be a class action. Well, personal injuries, just by almost definition, are never similar. Are you 20 years old or 90 years old? Did you lose time from work or were you retired? Did you pass away or not? Did you lose money from work? And if you did, how much? Were you making $30,000 a year? Were you making $100,000 a year? So, because the damages has to be similar, that's the reason why the law in the United States is that people who are alleging personal injuries, no matter how, can't be in a class. They have to be individual lawsuits. Now, there might be a whole lot of lawsuits, and there generally are. The federal court system might get inundated with these lawsuits across the United States, and they have a way of centralizing the litigation. So if you file a lawsuit in Alabama, it may get transferred to Chicago for the purposes of discovery, so that one judge can handle that one litigation, make one set of rulings, and everything is consistent throughout the United States, rather than having 20 judges, 200 judges, or more handling the same case, being confronted with the same motions, and maybe the rulings might not be consistent. So they centralized it before one judge, sometimes, if there's enough litigation to warrant centralization. States can't do that. Those states can centralize within the state, but centralize on a national basis. You can't send cases from California to New York in state court. If it was federal court, you could, but not state courts. So there's no such thing as class action. That's a misconception. So all cases against pharmaceutical and medical device companies, which by definition have to be for serious injuries, you can't afford to bring a litigation against a pharmaceutical or medical device company for something that is not serious. It just wouldn't make sense. Wouldn't make sense to the client, and it wouldn't make sense to the lawyer. They're all going to be individually filed in state or federal court. They may get centralized. However, all the cases are individually filed and they remain an individual case. And in federal court, if the cases do not get resolved during the discovery phase, federal court either could hold what they call bellwether trials on cases over which it actually has jurisdiction, meaning the parties, at least one of the parties are in their jurisdiction covered by that court, or the court can remand the case back to Alabama to get tried locally. You retain your jurisdiction in your case based upon where you filed it. In order to bring a lawsuit against a medical device manufacturer or a pharmaceutical company, the injuries have to be serious. It would not make sense for a client to bring a relatively small injury to trial, because the trial of a medical device or pharmaceutical in cash probably costs about $10 million and would take tens of thousands of attorney hours to bring it there, plus the paralegals and all the support staff. So it wouldn't be justified to bring something that was a small case involving a medical device or a pharmaceutical. But everybody's case is different. Is the person who's suffering from vision damage allegedly caused by Elmiron, are they 20 years old or 90 years old? Are they retired or still working? How much are they making if they're working? Are they making $20,000 a year or $100,000 a year? Is sharp vision important in your line of work? Some occupations, you really don't need to have that sharper vision. I mean, it would be nice and you'd want it, but it's not really affecting. For example, if you were a pilot, you couldn't be a pilot if you have Elmiron-related retinal toxicity. If you were a surgeon, you probably couldn't be a surgeon if you had Elmiron-related retinal toxicity. So everybody's damages are different. But I think we all can agree that you have damage to your retina that affects your eyesight so that you can't read, that you can't perform your daily functions, you can't watch TV. That's a serious injury and needs to be compensated accordingly. And that's what we fight for. Well, there's no guarantees about settlement, but we try to litigate our cases efficiently. Once we get involved, we try to move it as effectively as we can. It really depends upon the judge. Some judges have dockets that have a lot of cases, and they really have limited time for any particular case. Some judges' dockets are lighter than others. So it just depends upon the judge and how much time the judge could afford to the particular case. But we try to move them very quickly. Parker Waichman, as most other personal injury law firms, taking cases such as this, and in Elmiron in particular, do so under what we call a contingency fee agreement, where the law firm, Parker Waichman, will advance all the expenses of the litigation. You will not have to lay out any money for the litigation. We will lay out all the funds required to bring your case to trial. This could be very expensive. Doing discovery costs millions and millions of dollars. We're going to get, I would imagine, tens of millions of pages of documents and data from the defendants. Some defendants like to give us even more information than we're entitled to or that we need, because they flood us with documents. So you go try to find the needle in a haystack. But what we do is we hire experts who have electronic tools, who can mine the information that we get and ferret out those bad documents. Bad meaning bad for the defendants. Because at the end of the day, the one thing that I've learned from doing this for almost 40 years is bad documents drive damages. And when you could show the defendants committed bad acts, really bad acts, bad conduct, hid things they should have disclosed, that drives the amount your clients are going to get. That drives the amount our clients are going to get. And that's why it's so important that we do the work so we have firsthand knowledge of these bad documents so that it benefits our clients. It could cost us tens of millions of dollars, like I said, to bring these lawsuits on. But the advantage is that some clients will have, and I think almost every client, the advantage, like I said, it's going to cost a lot of money to bring this litigation to its conclusion, to a successful conclusion, successful for our clients. And in order to do that, we're going to be spending a lot of money. We have our document examiners. Those experts cost millions of dollars, and they get paid up front. We're going to have the best experts in the world, and they're very expensive. But that's what they cost. It's going to cost a lot for all the attorneys and paralegals that are dedicated to this case, and this case only. But the good thing is, and the thing that benefits our clients, is that Parker Waichman represents a lot of clients that are claiming that Elmiron has destroyed their retina. And a lot of the expenses that we've spoken about already will benefit all the clients. So if there is a resolution to this case, we could amortize or spread those expenses out over all of our clients so that the amount charged to a particular client is relatively small. If we only had 1 or 2 cases, or 5 or 10 or 20 cases, the burden to every client would be extreme. But because we represent a lot of clients in this litigation, they're going to benefit by having us allocate or amortize the expenses in an equitable way. Everybody's not going to get charged the same amount. It's going to be equitably done with court supervision or court-appointed special masters or with settlement administrators, and it'll be equitably done for all of our clients. So it'll be equitably done, spread throughout all of our clients. Now, some of the expenses are client related. For example, if we get medical records in your case from your doctors, those are your expenses. Those do not get spread to other clients. If we get a report from your doctor and we have to pay your doctor for that report, that is your expense. If we meet with your doctor and we have to pay your doctor for that meeting, that is not spread, that is your expense. But at the end of the day, based upon my almost 40 years of experience doing this, the way we handle it is most effective for all of our clients. And like I said, since we have a lot of clients, the more clients we have, the less it is for everybody. So I think the way we've worked it is most advantageous. At Parker Waichman, we generally do not believe the doctor has any direct responsibility in this case, or in any cases like this. When we go visit with the doctors of our clients, we almost always find the doctor was held in the dark. They were kept in the dark, just like you were, just like the FDA was. And they had no way to know that Elmiron had any toxic effect on the eye or the retina. They just had no way. Now, there might be an oddball out there. Did your doctor do the clinical trial? Was your doctor involved with the defendants along the line and learned something that nobody else knew? Well, that's a very odd situation. They're probably out there, but they're odd. So generally, we don't believe the doctors are liable. We believe the doctors were duped, just like you were. And therefore, this is not a medical malpractice case. And in our retainers, we will tell you that we're not going to be suing any doctors. And if you believe a doctor is responsible, well, then you're going to need to get yourself a different lawyer, because we're not doing it. We believe the doctors were duped just like you were. Now, if we do come across information in your case where we find the doctor was involved in the clinical trial, that he hid the evidence from the FDA, that he hid the evidence from others that were involved, other investigators in the trial, well, then we might have a discussion. But absent our finding of things along those lines, we have no intention to sue any of the doctors. I would say you should talk to your doctor about your injury. You should talk to your ophthalmologist about your problem with your vision. If you're having difficulty with your vision, you need to see your ophthalmologist and now discuss with him you're taking Elmiron and inquire as to whether the damage or to your eye was caused by Elmiron, and that maybe you need a referral to a retina specialist so you could have that non-invasive imaging test that we discussed earlier performed to diagnose whether your problems are caused by Elmiron. However, you should not talk to your doctor about the case, because you will now be releasing information that you very likely got from us. And that is protected by the attorney-client privilege. So we wouldn't want you to waive that privilege as to all your conversations with your doctor. So you do not talk to your doctor about the case, but you most certainly talk to the doctor about your problems with vision and what can be done to diagnose whether Elmiron is responsible and what can be done to treat the damage to your retina. Well, it's always a possibility that you'll have to go to court. The possibility that you might have to give depositions. What happens in cases like this, most of the time, is that the court will select a number of cases that will act as what they call bellwethers, samples, and that maybe the plaintiffs will pick a few, defendants will pick a few, and they'll go to trial. But there might be 10,000 or 20,000 cases filed, and they're going to pick 4, 6, 8. It's up to the judge, but it's a low number comparative to the number of cases filed. Some litigations, there are hundreds of thousands of cases filed, and they're only going to pick 6 or 12. So the chances of you going to court are slim. The chances of you going to depositions are slim. You might have to have a physical examination of your eye, but all that is very slim unless your case is picked as a bellwether. Well, hopefully you have medical coverage, health insurance coverage from your employer or the employer of your spouse. Medicare or Medicaid also affords medical coverage, so hopefully you have some way of getting your health care bills covered and the cost of the imaging that you need in order to make the diagnosis of Elmiron-related retinal toxicity. Well, there's not been a recall of Elmiron yet, In June of 2020, the label instructions that come with Elmiron was significantly changed to warn about the toxicity of Elmiron to the retina, as reported to the FDA and the manufacturer. In addition, in the warning label, it talks about the possibility of the damage to the retina continuing after you stop taking the medication. In my opinion, that's pretty serious. That's scary. And whether there'll be a recall in the future, I can't speak to that. But the warnings that have been released to the physicians and the patients regarding the potential dangers of Elmiron are now out there. They're now public. Sure. The Elmiron side effects are vision problems in general. It's blurry vision, difficulty reading, difficulty adjusting to dim lighting, problems with dark adaptation, glare, blind spots, muted, less vivid colors, where before you used to be able to see colors that would pop, now they're muted, night blindness, metamophobia, which is like a grid that has wavy lines and maybe blank in places, blindness. Everything that you tell us and that we tell you is confidential, highly confidential, and protected by the attorney-client privilege. That's why when you talk to your doctor, you talk to your doctor about medical things. You talk to him about problems with your vision. Talk to him about the time that you took Elmiron, the period of time you took Elmiron, whether you need to go see a retinal specialist, whether you need the retinal imaging that is able to diagnose whether you have Elmiron-related toxicity to your retina. But you never talk to your doctor about the litigation. You never talk to your doctor about things that we talk about. Because if you do that, while they originally were covered by the attorney-client privilege, you could be deemed to have waived that privilege once you start talking about privileged things, and we don't want that to happen. Another thing that's very important, and that we haven't discussed yet, is that the defendants are going to be asked, we asked the defendants for discovery. We asked them for their emails, their clinical trials, adverse event data, pharmacological data, all kinds of information. But they also ask us for information from you. They want us to look at your emails. They want us to look at your Facebook page. They want us to find any information that you've posted that would be relevant to this litigation. So I plead with you, keep everything to yourself having to do with this litigation. Don't post anything on Facebook. Don't be emailing your friends or relatives about your problems with your vision or litigation. This will be information that they will want, and this is going to be information that they're going to get. And they're going to use it against you as effectively as they can. So don't give them that opportunity. Keep everything to yourself, having to do with your problems, your eyes. Keep it off the social media. Keep it out of your emails.